AG, good afternoon. Thank you for taking time out to speak to us today. We're here to talk about the ruling Principal Magistrate Judy Latchman made today in relation to the constitutional application that was made in the extradition hearing in relation to the Mohammeds. In her ruling, the magistrate mentioned that she is not going to resuscitate what has already been put to rest, noting that the challenges that the points made before the court were already settled in higher courts. What are your thoughts on this?
Thank you very much for engaging me. No serious lawyer can be surprised at the magistrate's ruling. The last time we spoke, I mentioned to you that all the issues that have been canvassed before the magistrate are issues that have been canvassed to previous higher courts and conclusively determined. And that has been done on more than one occasion in different cases. By virtue of the doctrine of precedent, the magistrate, as a lower court, is bound to accept those rulings. And that's exactly what the magistrate did. So, no one ought to be surprised. The law in this area is quite settled now and is quite straightforward. So, I am not at all surprised that the magistrate ruled the way that the magistrate did.
AG, the defense attorneys mentioned their intention that they will be moving to go to the higher courts. As the Attorney General, what do you have to say about this?
You see, the defense, I heard them say that I should not be commenting on this matter. But this matter is a matter of national importance. It involves the government's treaty obligations. It involves our relationship with the United States and, by extension, our relationship with the outer world in battling organized crimes and money laundering and international financial crimes. And we have a particular position on this matter globally. So the Attorney General is positioned to speak on matters of this type. Secondly, the defense has a narrative that they are putting out there that is intended to confuse. And that narrative will not be allowed to stand. So the defense said that they are challenging the proceedings in the High Court. Again, I don't know what that means. The magistrate has said that the magistrate will proceed to conduct the extradition proceedings, and the magistrate has fixed the 6th and the 8th of January to do so. The defense, I suspect, want to go to the High Court in keeping with an express mandate and plan to prolong and protract these proceedings for 5 years. What would be canvassed before the High Court are the same issues that have been settled conclusively and ruled upon by the very High Court and higher courts than the High Court, to wit, the Guyana Court of Appeal. And I don't wish to go through all the issues again. Whenever a decision stands against the defense counsel, they have a tendency of saying that that decision is wrong. And whenever a decision favors them, they say that that decision is right. Fortunately or unfortunately, a single decision favors them. And all the other decisions in this country on extradition have been decided against the positions that they are advocating. One cannot stop persons from approaching the High Court. That is a right available to them. But that doesn't translate into a stay of the proceedings in the Magistrate's Court. And that's what's important. Barring, of course, they are able to get an order from the High Court staying the Magistrate. Because the Magistrate, having ruled that the questions are frivolous and vexatious, the Magistrate must now proceed, as she has indicated she will do. So I don't know what they will embark upon in the High Court. I believe is to relitigate the same issues that they have raised, which issues have been rejected by the Magistrate because they have been relitigated and relitigated and conclusively relitigated in higher courts. I heard a very strange new argument being advanced for the first time, that the authority to proceed issued under the hand of the Home Affairs Minister is deficient. Now, I am told, based upon the utterances in the press, that that was made after the Magistrate's ruling, which is strange because they had all the time to raise it. They have raised almost every argument available in extradition law and package it as if they constitute issues to be referred to the High Court and put them to the Magistrate, which the Magistrate recently rejected. That particular issue of alleged deficiency in the authority to proceed could have easily been included in that bundle of matters which they argued. They chose not to do that. Now, after the Magistrate has ruled, this issue is now being canvassed. Again, one is starkly reminded of that strategy expressed to delay and detain. And one can see a connection here again, bringing up new issues as the matter is unfolding. But what is important is that the authority to proceed is a standard form document that is in the Fugitive Offenders Act as a schedule. And every extradition case that has been done in Guyana, whenever that authority to proceed has to be done, one only has to look at the act and see the form at the back and follow the form. And I advised on the preparation of that form for the Minister of Home Affairs. And I not only looked at the form at the back of the statute, but I followed a bundle of existing authority to proceed. The contention, as I understand it, is that the authority to proceed ought to have contained the Guyanese equivalent of the offenses for which the extradition proceedings relate. There is no such requirement. Anyone who listening to me can go at the back of the Fugitive Offenders Act and they will see the authority to proceed form, and they will see that there is no allowance for any such item to be included. What the Minister of Home Affairs is authorizing the Magistrate to do is to proceed with the extradition request that she has received, the Magistrate, the Home Affairs Minister, in accordance with law. It doesn't say much more. It cannot say much more. So I believe that there's some type of confusion in terms of that contention. I believe it has no merit whatsoever and is a fabrication of someone's mind.
The magistrate has set January the 6th for commencement of the extradition hearing. What can be expected? And is there anything that the defense can do that can stall this process?
The dates that have been fixed is for the documents, is for the extradition hearing to begin. That involves the formal admission into evidence of the documents that were received from the government of the United States of America in relation to this extradition. They were sent, I understand, to the Ministry of Foreign Affairs and received by a particular official there. That official will say so and tender the documents that have been received. And the other issue is the dip note. Tender that as well. I heard a lot being said about the dip note. Let me say very quickly. As I said before, we didn't need that. They asked for that assurance. Our law has all the safeguards, and our treaty has all the safeguards required by our law and international law in relation to extraditions. And we have our Court of Appeal decisions that have interrogated that matter conclusively and settled it. And that's what the magistrate was referring to. So there is no ambiguity in that regard. But they asked for it, they want this assurance, and we have given it to them. Now they have received it, rather than be grateful and embrace it, I see that they are questioning it. And they are saying that it is not part of the treaty. If you read the law carefully, you will see that the law refers to an arrangement between two countries for the purpose of extradition. That arrangement can manifest itself in many ways. The treaty is only one. Countries make arrangements between or among themselves in different manifestations. Treaty is one. If a country decides to make arrangement by the exchange of diplomatic notes, that is a matter for the two countries. If that's what they consider themselves to be bound by, that will satisfy the requirement of an arrangement. And for that matter, in extradition matters, whenever the issue like the one they have raised arises, it is normally done by arrangements rather than go and execute a new treaty or amend a treaty. It is done by the exchange of diplomatic notes. And that is an outstanding practice in extradition matters. If not, an extradition will have to be stopped halfway, and two countries have to go back to the drawing board to renegotiate a treaty or amend a treaty. Does that make sense? So the exchange of diplomatic notes for the purpose of establishing arrangements required for these purposes is an accepted mechanism used by countries regularly across the globe. So that's not a contention with any merit either.